the issues, let me deal with them once and for all. First of all, if you read the 40-page ruling of the Supreme Court on this matter, which includes the dissenting opinions of the two justices who dissented on the matter, one of the main reasons they gave for granting this injunction against Honorable Quayson'S, the MP for Assin North, is that they say that according to the applicant, Honorable Quayson'S is in contemptuous breach of the Constitution of Ghana and the orders of the Cape Coast High Court. Because according to the applicant, Honorable Quayson'S was injuncted on the 7th of January from holding himself out as a member of Parliament. And yet he went to Parliament, was sworn in, and participated in parliamentary proceedings for that day. They also make the point that at the end of the hearing of the Assin North election petition matter, the Cape Coast High Court nullified the 2020 Assin North parliamentary election and granted a perpetual injunction against Honorable Quayson'S, restraining him from holding himself out as MP. And according to them, even after the High Court made this order, Honorable Quayson'S has been holding himself out as the MP for Assin North. And so, in their opinion, Honorable Quayson'S is in contemptuous breach of the Constitution and the orders of the Cape Coast High Court, and the Supreme Court should not allow him to persist, in that conduct during the pendency of the writs that they have brought before the Supreme Court. And the Supreme Court, on the basis of this, as has been reported by Graphic, says that, since the allegation is that Honorable Quayson'S is in breach of the Constitution, in breach of the Cape Coast High Court's order of injunction and all that, then we have to injunct him. Now, I cannot for the life of me understand why our apex court will grant an injunction on the basis of unproven allegations. What is the proof? Where is the evidence?
Are they not granting an injunction on the basis of a decision by High Court?
No, but it has never happened in the history of this country that the Supreme Court will grant an injunction upon an injunction. The Supreme Court cannot. I have never read any such case in all my training as a lawyer. No, hold on. The Supreme Court cannot grant an injunction to enforce an injunction. Number two, the Supreme Court is not the forum for the enforcement of orders of the High Court. So if the High Court has granted an injunction against Honorable Quayson'S,
is that what the High Court did?
That is what the High Court did.
I thought that what the High Court did was to nullify that election
and grant a perpetual injunction. That was one of the reliefs. So they have nullified the injunction,
the election,
yes, and they have granted a perpetual injunction restraining Quayson'S from holding himself out as MP.
Yes.
That's the High Court.
Yes.
And I'm saying that if you want to enforce that, there is a way to enforce it. Every lawyer knows how to enforce a judgment. Mm-hmm. You must first of all go and do your entry of judgment and enforce it against the person who is to do an act or who is to refrain from doing an act. There is a way to enforce, and you enforce that judgment in the High Courts.
So this is the position of the minority.
No. I'm going to. This is the position of the minority.
The minority view on the bench.
But I've not even gotten there.
Yes.
My first point is that the reason for granting this injunction by the Supreme Court is that the applicant, the one who applied for this injunction in the Supreme Court, let me simplify the issue, says that, look, injunct Quayson'S because number one, he was injuncted on 7th January not to go to Parliament and be sworn. He went. Number two, he's been injuncted by the Cape Coast High Court from holding himself out as an MP. And his elections have been nullified. Yet he's holding himself out as an MP. Mm-hmm. So he's in contemptuous breach of the Constitution. Mm-hmm. And so even before you interpret Article 94(2)(a) on whether or not he owed allegiance to a country other than Ghana at the time of his nominations, we want you to injunct him. And the Supreme Court says yes. Since the applicant is complaining about breaches of the Constitution, which is the supreme law of the land and which the Supreme Court must at all times protect and enforce, and since all Ghanaians have a community of interest in matters of constitutional enforcement, we will injunct Quayson'S. And I'm saying that, first of all, that is problematic because the allegations that the applicant has made have not been proven. It is not true that Quayson is in contemptuous breach of the Constitution or the orders of any courts. And I say so because, yes, the Cape Coast High Court gave an injunction, an order of injunction, made an order of injunction on 7 January. That is not in doubt. But was that order of injunction served on Honorable Quayson? Was it served on him and he decided to violate that order? It wasn't served on him. They, in their own words, claim to have served the clerk. And is that the way to serve a member of parliament, an order of injunction? So the Supreme Court, without taking cognizance of the mode of service of that injunction and whether that was proper or not, cannot accept hook, line, and sinker an allegation that Quayson defied that injunction. That's number one. Number two, they say that the Cape Coast High Court has nullified Quayson's election and has injuncted him. Again, has that judgment of the Cape Coast High Court and injunction been enforced by the applicants? Randy, I hope you understand what I'm saying. Has it been enforced? It hasn't been enforced. And it cannot be enforced because immediately after that judgment was given on 28th July 2021, on that same day, Honorable Quayson's lawyers filed a notice of appeal in the Court of Appeal and an application for stay of execution. And what that meant was that that judgment of the Cape Coast High Court and the accompanying order of injunction could not be enforced. And so how then can you say that even though Quayson had a notice of appeal and an application for stay of execution pending in the Court of Appeal, he was in contemptuous breach of the Cape Coast High Court judgment and injunction? It doesn't make legal sense. Now they say that, but the notice of appeal and the application of stay of execution was struck out for non-compliance at some point by the Court of Appeal. Was any evidence adduced before the Supreme Court that showed that even after the application of stay of execution and notice of appeal were quashed, Quayson still held himself out as MP for Assent North? There was no such evidence before the Supreme Court. It is also a fact that even after that purported striking out of our notice of appeal, a non-existent notice of appeal, because we filed the notice of appeal, Quayson filed it on 28th of July, in their indecent haste to dismiss that appeal unjustifiably, they referred to a notice of appeal filed on the 4th of August 2021, and Quayson did not file any notice of appeal on 4th of August. And so in that purported striking out of the notice of appeal and application of injunction, immediately after that, right, Quayson and his lawyers have filed an interlocutory appeal at the Supreme Court in the Court of Appeal, which is how you appeal decisions of the Court of Appeal. You file it in the Court of Appeal. Now, he has also filed another stay of execution of that unlawful decision, the decision by the Court of Appeal to strike out his application for stay of execution and notice of appeal, and has also filed another application to have the appeal relisted. And so it is very clear that you cannot listen to one party, the applicant, and come to the conclusion that Quayson is in contemptuous breach of the Constitution, for which reason the Supreme Court must injunct him. If we are to go by that logic, what that means is that when we went to courts to challenge the outcome of the 2020 election, presidential election, what was the basis of that election petition? We said that candidate Akufo-Addo, per the declaration of the EC chairperson, did not get 50% plus 1. And that was in clear violation of Article 64 of the 1992 Constitution. So we were also alleging a breach of the Constitution by the EC and candidate Akufo-Addo. So could we have also gone to the Supreme Court and said, Supreme Court, injunct President Akufo-Addo from holding himself out as president pending the determination of the 2020 election petition? Could we have done so? We could not have done so, Because on the balance of convenience, the Supreme Court cannot deprive the people of Ghana a precedent.
But in this case, has the Cape Coast High Court not already declared the election a nullity?
The Cape Coast High Court has already declared the
and
election
ordered the EC
a nullity,
to conduct
but that
fresh
decision,
elections.
yes, but that decision has not been enforced and cannot be enforced.
Why?
Because immediately after the decision on the 28th of July 2021, on that same day,
yes,
an application for stay of execution was filed and a notice of appeal was filed. What that means is that the decision has been stayed.
But the appeal has been heard and dismissed.
It has not been heard and dismissed.
So what was
hold on, so let's take it one after the other.
Yes.
First of all, that notice of appeal and application of stay of execution subsisted for a while.
Yes.
Okay, so for that period that those two applications were subsisting, you cannot legally say that Quayson was in breach of the High Court decision. That is why they never cited him for contempt, and that is why they can't cite him for contempt. Because if you go to the High Court and you secure judgment against me, and I defy the judgment, that's contempt. But if I go to a higher court and appeal that decision and I apply for stay of execution, I am not in breach.
But to the extent that the appeal.
So let's take it one after the other.
Yes.
So for the period that notice of appeal and the application of stay of execution was subsisting, he was not in contempt.
Yes.
Okay, now you are taking it to the next stage.
Yes.
That at some point, the notice of appeal was struck out. Striking out a process is not the same as dismissing it. Dismissing means it has been heard, and on its merits, it has been dismissed.
But if it's struck out
for non-compliance,
just hold on, for whatever reason, once it's struck out, does it not mean that there's no appeal pending?
So let me show you. So it is been struck out.
Yes.
Then immediately it is struck out. The decision to strike out, two, an application of stay of execution has been filed against it.
Has it been granted?
No, but the application for stay of execution is pending. The first one had not been heard and determined.
Yes.
So,
but I'm asking whether the application
has not even been heard.
So it's not been granted.
Yes.
Okay.
But that application has been filed.
Yes.
Are you getting me?
But it's not been granted.
It's not been granted, but it is active. So the decision to strike out the notice of appeal and non-existent notice of appeal filed on 4th August, which is not the notice of appeal Quayson filed, and the application of stay of execution.
Maybe it was just a typo, it was a mistake.
Well, I'll come to that later. I'm saying that that decision, in our opinion, and if you are to do a true and proper interpretation of the law, has not kicked in, because there is an active application of stay of execution against that decision, purported decision to strike out the notice of appeal and the application of stay of execution. And in addition to that, a notice of interlocutory appeal has been filed in the Court of Appeal for the Supreme Court to determine that matter. Again, an application of certiorari has been filed in the Supreme Court to quash the Court of Appeal's decision to strike out that notice of appeal and application of stay of execution, because they didn't give lawyers of Honorable Quayson even a hearing on whether or not they had complied, they were compliant or they were not compliant. There was no hearing. They referred to a non-existent notice of appeal. The presiding judge who decided to strike out, who presided that day when the Court of Appeal decided to strike out that notice of appeal and application of stay of execution, had a pending application of disqualification against her. Yet she continued, she proceeded to hear and determine all those issues. So I'm saying that, technically speaking, the claim that Honorable Quayson is in contemptuous breach of the Constitution is a one-sided claim by the applicant. There is no evidence that indeed he is in contemptuous breach of the Constitution and the Cape Coast High Court before the Supreme Court. And so how can the Supreme Court rely on that and say we are injuncting you? So if I go to the Supreme Court today and I say the Techiman South MP's 2020 parliamentary election, there was no coalition, and that violated the Constitution of Ghana, and so he should be injuncted. Because I'm alleging a breach of the Constitution, an injunction should be granted. That's the first point I'm making. Rand, did you understand? Number two.